This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I am Stuart Address for Ask a Lawyer. And the last I checked, I am still a lawyer. So we do have a call already waiting on line one. I don't have a name, but whoever's waiting, can I help you?
Hey, Mr. Stewart. My name is John, and I had a question. I know you know something about condominiums, right?
I do some HOA law, yep.
Okay. Well, we had a special meeting of our members. The first time we've had one in 25 years, as long as I've lived here, and they wanted to amend the docs. So to make a long story short, the people come walking in, they have to sign in. Well, they were having them come in with the proxies because the proxies had a ballot on there for the amendment. And it regarded the reserve accounts and whether to move them into a pool reserve. So they were handing in their proxies and voting with the proxies as they were attending. Not only that, but after the votes were tabulated, the manager, I guess, took over the meeting, like she always does, and announced that the votes was overwhelming in favor of yes. The trouble was, though, the docs specifically say that you need a majority of the entire membership.
Okay.
Not a majority of the vote. And
right.
They kept telling me, no, we talked to our lawyer, and the lawyer says we just needed a majority. So how do you, I mean, the state, I called the state, they don't get involved in this. You know, it's elections, finance, and records. That's all they do these days. I mean, compliance is teethless. They won't help you.
If the association docs require approval to be a majority of the entire association, all unit owners.
Mm-hmm.
And if it's, I mean, there are those that do say that, it's very clear, then your action would be in court. It would be a declaratory judgment to declare the vote as void and to rescind any action taken in furtherance of the vote.
Mm-hmm. Yeah, now here's the hard part. The vote was overwhelmingly in favor of going to the pool, and they were still 20 votes short of a majority of the entire membership.
Okay.
So if I'm the bad guy, because the question was, you can vote for A, which is the pool, which is a lower amount, because pool reserves always are a lower amount, and the assessment increase would have been a lower amount. So instead of $200, if we didn't vote for the pool, if we stayed with the straight line, it's $350. So if I go to court and fight this thing, I'm going to be the bad sheep in the neighborhood.
You're right.
I may be paid $150 more because they weren't following the docs.
Well, sometimes we have to choose whether or not we want to be the bad sheep and bear the cross of people who express disapproval. The only way to challenge that is to take it to court. Certainly, it doesn't appear that they're going to fix it themselves, especially if they believe that they have legal advice that what they did was okay.
But I asked them for the legal advice because usually when you call your attorney and you always, excuse me, but, they could have read the docs. They didn't need to call the attorney and waste $300-400. I mean, there's a time when you call your attorney for the association and there's times you don't. And this was one of them where they didn't have to. Anybody can read it in black and white what the docs say. But with that said, once they called the attorney, shouldn't he give me the chapter and verse, give them the chapter and verse so that if I question it?
Not necessarily, because for the attorney to have given them an opinion letter would have cost another $300-400.
No. What I'm saying is when they called him, shouldn't they say, listen, if somebody gives you a hard time, it's right here in section blah, blah, blah. I mean, they didn't even get that information out of the attorney because I asked the property manager, I said, where in the docs does it say that? I'm pointing to right where the docs are.
Right.
It says how to amend the bylaws. Shouldn't the attorney have said if there is a
well,
different
you don't know that the attorney didn't say that. You just had the property manager, under duress because he or she was being challenged, and didn't give you the response that you wanted. They may have been given a provision. They may not have been given a provision. I have no way of knowing. But the only way now to challenge that, certainly the association attorney answers to the association officers. Not going to answer, to a unit owner. So the only way to challenge it and to find out what really happened is to challenge it in court.
Yeah, I see. One other quick question on a separate note. If someone is being harassed by a bill collector, collection agent,
okay,
is there a special attorneys, and I know attorneys specialize in different stuff, but if they ever get a letter that they're being sued, is there a certain class of attorney that specializes in those situations?
Most general civil litigation attorneys like myself deal with those. You'll see some that advertise consumer law. Obviously those attorneys would deal with them. When you're being hounded, as I can relate to with people that I know from debt collectors, the quick and easy way to stop it is to tell them and put it in writing that you want them to cease all communications with you in accordance with the Fair Debt Collection Practices Act, except for service of process. In other words, stop talking to me unless you're going to sue me.
Yeah, and I understand that, and I appreciate that, and I've done that. It's just the service of process I'm expecting someday, because eventually they're going to sue if I don't respond to an illegitimate bill, that's what I consider illegitimate. But there's no certification, like in condo. There's certified condo attorneys. They have to be certified through the state because I guess they take special courses.
No, there are no certified debt collection attorneys. No.
Okay. Thank you very much.
You're very welcome. Take care. Thank you for calling.
I think on that first issue with the condo is that he needs to find a condo association whistleblower.
Well, he would be he would be the one. But before you're going to challenge that, first of all, I think you need to be confident that if a vote was taken of all the owners, that they wouldn't have that majority. That the people who were absent and didn't vote would not ultimately vote in sufficient numbers to maintain a majority, because otherwise all you're doing is challenging the process, but the result will be the same.
Our association, like, when they have elections and stuff like that, they mail a proxy to every house.
Right. But it doesn't mean everybody votes.
Oh, I got you. Okay, yeah, that's true.
So some documents...
that's true.
Some documents say a majority or 2/3 in certain situations of those present and voting, as long as you have a quorum. Quorum usually being defined as at least 50%.
Gotcha. Yeah.
Other docs say, as he says here, a majority of all unit owners.
Mm-hmm.
So if there are 100 unit owners and 80 vote, you still need 51 to get approval.
Sure.
And not 41. And you have to be careful in making sure you're following the proper requirements, and you're making sure that you have a proper quorum and that you're calculating the vote in the correct way.
Mm-hmm.
Otherwise, the association could end up paying somebody who challenges it their attorney's fees. And the reality is, I know what that sounds like, because who ends up paying those attorney's fees? All the unit owners in equal portions.
Sure.
So,
yeah,
I can understand people being upset with somebody who takes on the HOA when it increases the cost to them, but sometimes that's the only way to rein in, an out of control, HOA, COA, depending upon what you're dealing with.
Yeah. Okay.
Anyway, I had closed last week. We were talking about mediation, and I promised that I would go into arbitration and explain the differences. So I'm going to do that, and then we're going to go to a politilegal topic, if that's a new word.
Politilegal.
A politilegal.
Cool.
A legal poly.
There you go.
A look poly, whatever we want to call it. Okay, arbitration. You're going to find that there is an arbitration provision in a lot of contractual agreements that you sign. That could be buying a car. It could be buying a home. It could be entering into an employment agreement. It could be in any credit cards. Look at the fine print. Very often you're going
What
to see,
fine print?
Yeah.
Yeah.
Very often, you know all those terms of service that everybody clicks. Okay?
Oh gosh,
Well,
I never read.
Yeah,
that
hidden
stuff.
in there might be an arbitration clause that says you have to arbitrate in Omaha, Nebraska.
Yeah.
You know, why is this done, and is it enforceable? Well, let's take the second one first. Simple answer: yes, it is enforceable. Arbitration provisions and agreements are considered highly favorable by the courts because it takes matters off the court docket. So if you have signed an arbitration provision, whether you knew it was in there or not, it is almost certain that you're going to be stuck with it. And with that, we go to Patrick on line 1. Hello, Patrick. How can I help you?
Good morning, Stuart.
Good morning.
I have a question. My son had 2 suits. He lives up in New Jersey.
Ah, where I was
suits.
from. New Jersey.
He's in a small town called Wantage, New Jersey.
Where, New Jersey?
Wantage, W-A-N-T-A-G-E.
I don't think I've heard of that. Where is that?
Well, it's subject to Essex. I keep getting
Okay,
mixed
up in northern New Jersey. Okay.
Yes, that's correct. So he had 2 suits in this dry cleaners, and Sunday morning the dry cleaner burned down to the ground. And I was wondering what action can he possibly take, or what steps to take.
Was this in Florida or New Jersey?
No, this was up in New Jersey.
All right. Well, I'm going to tell you that the general black letter stuff. Obviously, I haven't not practiced in New Jersey since 1993, so I don't know precisely New Jersey law. But I would strongly suspect that you have a small claims action against the dry cleaners for the value of the suits that were lost in the fire, and that the dry cleaner is going to be making a claim, for his damages, including the lost property of other people, to his insurance company. But that's most likely the way it would proceed.
So he should try to find out what insurance company the dry cleaner has.
Oh, no, the dry cleaner's insurance company is not going to talk to him. Either the dry cleaner is going to say, I'll write you a check, or the dry cleaner is going to say, let me deal with my insurance company, give me 3 to 6 months, which, is not that unreasonable given the amount at issue. Or your son would just file a claim in small claims court, and I'm sure New Jersey works pretty much the way we do. Probably you'd get called for a pretrial hearing, a mediation, within about a month or so. And I would guess that the dry cleaner would probably admit responsibility and say he's trying to collect from his insurance company, and he'd probably beg for more time. Ultimately, if push came to shove and you had a small claims trial, the dry cleaner would probably lose. The judgment would be entered. Then the question is, how are you going to collect on it? If there are no more assets of the corporation, let's say, because the dry cleaner is burned to the ground, unless he has 5 others, you may have a hard time collecting. But if the dry cleaner is sort of willing to pay but needs time to get the money from his own insurance company, you're probably going to see your money.
So would the first step be, if he knows the dry cleaner's home phone number, to contact the dry cleaner and go from there?
Well, if they know how to get in contact with the dry cleaner, I assume mail is being forwarded. You could send a letter, to the dry cleaner even at the burnt down address. I'm almost certain that mail is being forwarded somewhere, and see if the dry cleaner responds.
Yeah, he's local. He supposedly lives in Wantage and been in business for over 25 years.
If he's that local and you know the last name of the guy and you can find him at home, I know I once tracked down a florist that closed right before a wedding, and I tracked them down at home and wanted my money back.
Okay, that's what I'll tell him to do.
All right.
Thank you so much.
You're welcome. Take care, Patrick. Thank you for calling.
Have a great one.
Now, if they were $10,000 Giorgio Armani suits, is that still small claim?
Well, if you're gonna claim they're $10,000 Giorgio Armani suits, you may have to prove that is what you gave to the dry cleaner, as opposed to 2 ratty suits that go for $99.99. And then you're probably outside the small claims value, whatever it is in New Jersey. Here
Sure.
in Florida, it's $5,000. All right, so unless we get another call, and until we get another call, which would be wonderful, and it's at 340-1590. As they like to say on radio and TV, they double it. That's 340-1590. You're going to find these arbitration provisions in a lot of places that you wouldn't expect. And a lot of times they'll require arbitration in Delaware, New Jersey, and Idaho, wherever the company wants it to be. And it is enforceable.
Oh, come on.
Yes, it is enforceable. You accepted it. Doesn't matter if you didn't read it.
Oh,
So,
man.
what are the general benefits and disadvantages to arbitration as opposed to being able to go into court and litigate? Arbitration is completed much, much quicker. An arbitration matter may be over in a matter of 3 to 6 months, whereas litigation may take anywhere from 18 months to 5 years. It does get resolved much quicker. It's also much less expensive. Usually you're still going to use an attorney, if the amount is anything significant, but there is a much shorter period of time that attorney has been retained, so of course that decreases the expense as a result of time. Also, and here comes a disadvantage, I think, although it's an advantage to a decrease in fees, there is much less opportunity to conduct discovery in an arbitration. That usually works to the corporation or the business benefit, not the individual, which is why if I see an arbitration provision and I'm representing an individual, I tend to want to try to exclude it or knock it out if I can. And I don't mean when it's enforceable, I mean before a document is ever agreed to, signed. Just try to get rid of it. Sometimes I'll negotiate, well, let's get rid of the arbitration, but we'll include in the contract a waiver of a jury trial. So it just goes in front of a judge, because a bench trial is also less expensive than a jury trial. So sometimes that's a compromise, I'll try to negotiate.
Which do you like? Do you like juries, or would you rather just go before a judge?
It depends entirely on the case.
Okay.
And on whether you're appealing to a strict legal formula, because the law is clearly on your side, or whether you're trying to get emotion to play into it.
Okay, yeah.
You may still have the law on your side, but when it comes to damages, a jury is almost always going to give you more money than a judge is. A judge is going to be very precise, analytical. There's no emotion involved. When you're trying to argue pain and suffering, judge may look at, okay, this is how much you've had in therapy expenses, and how bad the therapist says it is, and based upon my experience for 30 years on the bench, I'm going to award you whatever.
Right.
That analysis is almost robotic. Okay? Whereas if you have something that involves pain and suffering, I want a jury. I want an opportunity to tell a story, a narrative, to a jury, to argue to a jury as to what I believe this is worth and why, and to try to persuade a jury that it's worth more than perhaps a judge might award.
Mm-hmm.
So it really depends upon the case. If I have certain types of cases, like, for example, recently I had a medical practice where the two owners were fighting with each other. They couldn't agree on anything, and the only way to resolve it was to try to, quote-unquote, dissolve the corporation because of a deadlock. And we didn't really want to dissolve the corporation. We wanted to get the other parties to sell to us. But the only action legally was to dissolve. So we filed an action on behalf of the corporation, derivative action, to dissolve the corporation. We did not ask for a jury trial. If this matter had actually gone to a trial, I would have wanted that to be decided strictly by a judge, because the law is black and white. I would have been able to show 20 different deadlocks of significant decisions that couldn't be made by the business because the two partners wouldn't agree with each other on anything. And so I believe a judge would have strictly applied the law and given us the relief we sought. A jury could have been spellbound by a very good opposing attorney. I wouldn't want to take that risk. So in that type of situation, I would want a bench trial. And very often, before I file a complaint, I have a discussion with my client as to whether or not it is better to ask for a jury trial in the complaint, because that's the only time that a plaintiff can do it. If you don't put it in the complaint, unless the defendant demands it in the answer, there's no jury trial. You can't come back later and say, I want one. So I'll have a discussion with my client. Do you want to demand one? What do you think? Well, I'll say, okay, here's the pros of a jury trial, and here are the pros of a bench trial in this particular case. You know, if it were me, I would probably want this, and invariably the client's going to say, okay, we'll do that. But every case is different, and what you're trying to accomplish is different in every case. It's not always just how much money. And even when it is how much money, if it's a type of case where you're not trying to appeal to anybody's emotion, sometimes you may want a judge so that the other side can't just throw darts everywhere and confuse the issue, because a judge is usually much better at separating the wheat from the chaff. So it's a little bit more of a complex question than one might appear at first blush.
Interesting, though. Yeah.
So you do have less discovery. I don't really like that when I'm representing an individual, because the arbitrator is going to determine how much discovery he or she is going to allow. They are not required to do anything by the federal courts and the state courts. They control their own, let's say it's the American Arbitration Association. They control what they want to handle their arbitration. You've chosen them, so they handle it. If they want to allow one deposition, they allow one deposition. There's no appeal to a court. You can appeal to the arbitrator, but there's no appeal to the court that you should get more. So you could be stymied if you're an individual and you need materials from the defendant to prove your case.
Sure.
So in those situations...
See, I thought that was automatic, that they
No.
had to share that.
No. In those situations, if I'm looking at this ahead of time, I don't want an arbitration provision. Now, if I'm representing a business, which I do sometimes, very often I will suggest to the client we put in an arbitration provision, because we get it resolved much quicker and with less discovery, because now I'm on the other side of the table. Lawyers speak out of both sides of their mouth, right?
Oh, come on.
So it depends. Now, how is an arbitration different than a mediation? Last week we were talking about mediation. The mediator has no authority to make any decisions, can't order anything. The sole job of the mediator is to try to bring the two parties together to negotiate a number that they can both live with and walk out of there with a deal. And the mediator uses powers of persuasion. The mediator will point to weaknesses in both sides' case to try to get them to move off their numbers. An arbitrator is different, and you may have one arbitrator or a three-arbitrator panel. Again, that could be in the contract, or it could be subject to election under, let's say, the American Arbitration Association rules. I prefer a three-arbitrator panel. One picked by one side, one picked by the other side, and the third one picked by those two arbitrators.
How much does that cost?
It costs a little bit more, but less than litigation.
Oh, okay.
It may cost another few $1,000s. I would much prefer to have an arbitrator that I like, that I feel comfortable with, just like the other side's going to have one like they like. And then presumably those two are going to pick somebody they respect, who hopefully will be like the independent arbitrator that's not selected by anybody. And my goal is to try to get a 2-to-1 decision. I would much rather have the opportunity of persuading all three, because just because you pick the arbitrator doesn't mean you're getting that vote. And just because the other side picked their arbitrator doesn't mean they're getting that vote. Now, I have an opportunity to get 3 votes. I only need 2. I'd much rather do that than place all my eggs in the basket of one arbitrator, just like if you have a bench trial, it's in one judge.
Yeah, it's kind of like you hear the stories about various political parties that, favor various Supreme Court justices, and this guy's conservative, but he votes liberal.
That's right.
This guy's a liberal and votes conservative. It's like
They
crazy.
surprise you. They surprise you because...
Well, they're independent. They're supposed to be.
They're supposed to be. They're there for life. And sometimes they also are influenced by their colleagues, by the logic and persuasiveness of the arguments made behind closed doors by their colleagues. They are supposed to, we're deviating a little bit, Supreme Court justices are supposed to approach matters with an open mind. Now, they may have a philosophical bent, absolutely, but they're supposed to be approaching it with an open mind, subject to being persuaded by another one of their fellow justices. And that's how you hope that, we get decisions that reflect the law as opposed to decisions that reflect, political parties. The other difference is in arbitration, it's like a mini trial. You may do it around a conference table, but it is a trial. The arbitrator does not do shuttle diplomacy into separate rooms. The plaintiff presents their case, calls witnesses, introduces evidence. The defendant calls witnesses, introduces evidence. There may be opening statements, closing arguments.
Now, is this in an office or is this like
No, usually in an
courtroom?
office.
Courtroom.
Oh, it could be in an office in any conference room.
Oh, okay. Okay.
And, the arbitrator may render a decision right then and there, or may more typically tell you, thank you, the case is submitted, and, in a week or so you may get a written opinion from the arbitrator or the arbitration panel indicating what the decision was and why, just like a judge would write an opinion. Those things then, if one side doesn't do what they're told to do, are enforceable in court. You apply to make the arbitration award a judgment, and you can make all the arguments you want against it, but the reality is it's called a plethora. There are tons of case law that say, unless you're going to be able to prove that an arbitrator was biased or committed fraud, something like that, the arbitration award is going to be ratified by the court and entered as a judgment. So no belly aching, you better be able to prove that something wrong went on in that arbitration. Otherwise, that arbitration stands as final, non-appealable. So
Bribery.
That's really the difference.
Bribery. Oh.
Yeah, bribery. Well, using that word. Let's now transition to the paralegal.
Oh, yes.
Let's talk a little bit about impeachment.
I've heard that word recently.
Okay. Now, as much as most people who do listen to the show know my political bent, this particular topic that I'm going to attach right now, I'm going to try to do really very neutrally. I want to lay out something so that people understand. Consider this informative speaking, not persuasive speaking.
I wish you would.
Okay? Why should a House of Representatives, any House, including this particular House, impeach if conviction in the Senate is unlikely? I mean, why bother to impeach if nothing's going to happen? The president's not going to be removed, whether it's this president or any president. There are arguments that go both ways, and this has been debated by constitutional scholars, and I'm just going to give you some of what sort of a synthesis of what they've said. Ordinarily, it would not make sense for a House to impeach if it is clear that the Senate is not going to convict, typically. The most obvious reason to impeach somebody is because there's an urgent need to remove them from office. Whether it's a judge or the president, doesn't matter. That's usually the reason why you're seeking to impeach.
Mm-hmm.
So if conviction is off the table and removal can no longer be the justification for the impeachment, then why impeach? There are reasons, and there are reasons not to. So for example, why should we not do what we're doing right now if we believe that President Trump will not be convicted in the Senate? Why should we, not do it? Well, if the entire purpose of impeachment is to remove President Trump from office, and he remains in office after the attempt, then the impeachment has failed. Its purpose has failed. If the goal is to stop a string of abusive behavior that can no longer be tolerated or checked by other means, and there's not going to be a conviction in the Senate, then the purpose of impeachment is failed. doesn't mean no reason to do it. If the goal is to address a basic incompatibility between the behavior of an office holder and the expectations of the office, and that incompatibility still remains at the end of the day, then the impeachment purpose has failed. There's no reason to do it. If the goal of an impeachment is to stop an office holder from continuing to exploit his or her governmental office for personal gain, and the officer continues to be able to do so because they are not convicted, then the purpose has failed. Now, I know in the current genre where we have impeachment hearings on TV right now, a lot of people are talking about those goals. We got to remove Trump from office. Personally, I want to see him removed too. I don't believe it's likely. So why bother with the impeachment?
The cost is what bothers me.
Well, the cost is, this is what they do for their living. It's, no big cost.
It's D.C. It's like, who cares?
Here are reasons to do an impeachment, even if you know that the subject of the impeachment is not going to be removed from office. And this comes, again, it's a synthesis of what various constitutional scholars have written. Impeachments can be and have been a vehicle for constructing, consolidating, and reinforcing an important set of constitutional norms. So if the goal is to set, this is the standard we expect, even if the person is not removed from office, the House has at least established this is the expectation of behavior in the future.
Yeah, but they're not going to get that with this guy.
Not with this guy. That's the whole purpose. Even if you know you're not going to get it with this guy.
Okay.
You are establishing this is what we expect.
For the future.
Right.
Okay.
If it is a means of asserting that some behavior is beyond the pale, you can impeach because it's a warning to the future office holders. We have set a boundary here. We don't believe this is acceptable behavior. If the purpose is to send the strongest possible message that some behavior is to be condemned and should not be imitated by others, that even though a high government official can be engaged in some behavior, this behavior should be understood as disgraceful rather than exemplary. That is a legitimate purpose for impeachment, even if you know you're not going to get conviction. You're setting a standard, you're communicating a norm of the country, a norm of the Congress, what we expect out of an office holder. Again, here it's the president, it could be a judge. Norm creation and norm reinforcement have long been part of the American experience with the impeachment power, particularly when the House sets its sights on the highest government officials. For example, we're going to go way back now. The Jeffersonians impeached Associate Justice Samuel Chase so that judges would understand, in no uncertain terms, that political partisanship should have no place on the federal bench. Chase had distinguished himself for the partisan enmity with which he held the Jeffersonians. In other words, he hated them. And his impeachment helped recalibrate expectations about how life-tenured judges should behave in a democratic but partisan political environment.
Wow.
Okay? Decades later, the Republicans impeached President Andrew Johnson, who came within one vote of being removed from office, because he was engaged in an unprecedented obstruction effort that relied on an expansive view of presidential authority in the high-stakes context of the aftermath of the Civil War and the midst of Southern Reconstruction. Now, if we take out Civil War and Southern Reconstruction, it sounds like what's going on today.
Does.
Okay?
Does. Yeah.
Both Chase and Johnson were impeached by the House, but acquitted in the Senate.
God.
In both cases, political parties sent the message that you should not follow the lead of behavior by either the Associate Justice as to how a justice of the Supreme Court should behave, or as to how the president should behave. And indeed, President Johnson made a deal so that he would not be removed from office, which is why it became one vote short. And the deal included behaving, doing the things that he was expected to do and not doing some of the things that the Congress was upset about.
Okay.
And we hope that these reasons are sometimes reasons for an impeachment, even if the end result is not removal from office. So, if people are going to crow, as they will, let's be honest, Trump's going to be impeached, okay? Let's be honest, unlikely he's going to be removed from office. The Republicans are then going to crow and crow that we win. Well, you did. You won that battle, okay? If that's what happens, you won. But, more importantly, the country won because of the impeachment, no matter what you believe, because it was the House of Representatives, hopefully with some Republicans going along with them, because that makes it stronger, saying this is a norm, this is to be expected, that is not to be tolerated, and hopefully in the future somebody will decide not to risk removal from office by engaging in similar behavior. So that is, there can be an impeachment here and not a conviction. And it is not a Democratic loss, maybe a Republican victory, but it's not necessarily a Democratic loss. It could simply be a victory for constitutional democracy and sending the message that we don't approve of this. This is not what we believe is appropriate behavior for the President of the United States. Does that prevent somebody else from doing it? No. Unless you're eventually going to remove somebody from office, which we've never done in our country, which should show just how stable our democracy really is. This is not a third world banana republic. We do not have coups.
No, Florida is.
Okay. We try not to be a banana republic. Even though we have these provisions in the Constitution, and they are being exercised right now in the House, the country has never actually removed a president from office.
Nixon would have been.
And that is the amazing, coincidence. It's not a coincidence. It's an amazing constitutional principle. I look back on that era, and I've read some books because it really becomes more important to me now in the context of what's going on today. Nixon would have been impeached and removed from office by a Republican Senate.
Oh, yeah.
Why? Yeah. Why? I've said this on other shows. Why? Because the Republicans were so embarrassed, were so disgraced by the actions of their president that they stood up and communicated this is not tolerable in a democratic constitutional society, and we will remove you from office. And so Nixon resigned. I thought for the longest time that would eventually happen here. I truly believed, now I am going into partisanship, I truly believed that at some point enough Republicans in the House and the Senate would stand up, take notice of what is going on, whether you want to talk about Ukraine or Russia or what's called the Emoluments Clause, which is benefiting from being in office financially, and say enough is enough. This is a democracy that we swore to uphold the Constitution. We are going to tell our president of our party, we are not going along with this anymore. Frankly, I thought Republicans were going to say, finally, this is our opportunity to get rid of this guy. Let's put in a real politician. Let's put in Pence. I don't love that either. But let's put him in. We'll run somebody decent, in 2020. I thought Republicans were going to jump all in joy and say, we could finally get rid of him. I was wrong. I don't understand what I'll call the Stepford Republicans and why they are marching in order. I think it's inconsistent with what happened in the Nixon era, where the same Senate with the same Republican majority told the president, you're gone.
You're done. Yeah. Oh, yeah.
Okay? You're not going to do this. And let me tell you something, folks. What Nixon was accused of doing pales in comparison to what Trump is accused of doing. I mean, Nixon obstructed justice Nixon lied. Nixon was caught in a cover-up. But Nixon did not do anything wrong until he started to try to cover it up.
Look, come on.
Nixon was not part of the underlying offense of Watergate. I don't believe, at least, and the scholars don't believe, that Nixon knew ahead of time that these guys were going to go into Watergate and try to burglarize a Democratic committee.
They're all USC buddies.
All right, but let's assume Nixon didn't know anything.
Okay.
Then his crime was covering it up.
Yes.
And the Republicans were going to say, no, we're not going to allow you to do that. We're not going to allow you to fire special prosecutor after special prosecutor because they won't do what you want. We're not going to allow you to abuse the office like that. That is nothing compared to what President Trump is accused of. That is nothing compared to what President Trump has admitted before microphones on TV. Honestly, it's nothing. Whether you like Trump, you love his policies, you think anybody who hates Trump is, scum of the earth, it doesn't matter. What President Trump has admitted, forget what he's accused of, what he has admitted far, in my opinion, exceeds the allegations against President Nixon. And in that era, the Republicans stood up and said no. And I honestly, having a degree in political science and an undergraduate associate's certificate from the Eagleton Institute of Politics, I honestly believed that at some point the Republicans were going to get together and say, this is destroying our party. We can't allow this. This is not where we want our party to go. And we're going to do what's necessary to get rid of him.
But do the Republicans look at him as kind of a maverick anyway because he, always voted Democratic?
I don't know what the Republicans look at him as. Privately, everybody says most Republicans despise him.
Mm-hmm.
A lot of Republicans are afraid of him because, he'll come out against them, he'll tweet, and he'll go campaign against them in a primary, okay? And all his 38% will, come after you. So a lot of them, it seems to be running scared. That's an embarrassment. That's an embarrassment to the oath of office. It's an embarrassment to your legacy. I mean, we have legacies of heroes in this country. We have legacies of people who have gone against the grain. And we have legacies of people who have wimped out. We have, in the McCarthy era, we have legacies of people who went along with Senator McCarthy and all communists, everybody's a communist. If even somebody says you're a communist, we're gonna condemn you, blacklist you. That is a black stain on this country. And all those who went along with Senator McCarthy, their legacy, that is part of their legacy. And those who stood up to Senator McCarthy, they have a legacy as well. You don't think that 10, 20, 50 years from now, there will be legacies of senators long gone, what legacies they want for their life?
Sure.
And that a stain may be that they supported a president who 50 years from now, 20 years from now, it's generally accepted, did X, Y, and Z, and that they wouldn't stand up and say no. That's their decision, I guess. It's what they may have to live with. It doesn't mean I win right now. I certainly don't. I don't believe that Donald Trump's going to be removed from office. I certainly hope with all my heart that he will be defeated in 2020. Earlier in his presidency, when people would say he'd win again in 2020, I'd laugh hysterically because I didn't conceive it was any possibility of that. Again, I'm wrong. I concede there's a possibility this guy could win again.
Well,
I don't
there's no
understand
candidates.
it. I don't understand it, but I concede it.
Yeah, there's no other candidates out there. I mean,
why people would, vote for somebody who has done what he's done in office, why people would vote for somebody who's mocked a disabled reporter, bragged about grabbing women, by their genitalia, and everything else that he admits, why they would vote for that, I don't have the foggiest. I have to admit that as a student of political science, I've been getting it wrong. My assumptions, my assessments of what would eventually happen so far have been wrong. And, I'm not embarrassed by that. I'm a little bit surprised.
A little chagrined.
I'm a lot chagrined.
Yeah.
I thought I could evaluate the duty to country a little bit more and guess what would eventually happen. It hasn't. I thought about the people of the country as well. It seems I could be very wrong. There is one thing, and I'm not saying I'm a Biden fan. I don't know at this point. But there is one thing that Senator Biden says that I agree with. 4 more years of Donald Trump will forever change the nature of our constitutional democracy. And that is scary, because that is the legacy for our kids and our grandkids, our great-grandkids, what country we will leave with to them. And I don't mean whether it's clean air or clean water. I mean, what kind of a democracy are we going to leave them? Because if the highest office holder in the land can violate constitutional principles without any consequence, what are we telling everybody else who's growing up? What are we telling every student? You can get away with it if you're careful, if you're charismatic. All right? You can find a way, if you plan carefully enough, to get away with it. I don't think that's the message we want to send. I never thought that in our country, just like I never thought I could be president, okay? I don't think I have, well, I think I could be given who's in office right now. But before that, I didn't think that I had the ability to work the longer hours that are necessary, given all his executive time I do. I didn't think that I had enough knowledge, intelligence. I just didn't think I had enough savvy to make the hard decisions that a president has to make. I don't think he does either. I think it's generally accepted that in many instances he doesn't. People ask him questions about a foreign country, he doesn't know what he's talking about. Sometimes he pretends he doesn't know what he's talking about, or pretends he does know what he's talking about. I mean, the guy is amazing. He's amazing that he's convincing people and has a following the way he does. But I would rather the message to our children, etc., be that only those of the highest skill and the highest integrity can and should be seeking office of any kind, especially in Washington, D.C. That you need impeachable character. One of the things I've tried over and over and over for years, folks, to drill into my kid, who's 15 and a half, the importance of honesty, truthfulness, and character. And every time he would lie to me, I'd catch him, or I'd cross-examine him for a good long time until he broke. I would try to impress that upon him, and I will go to this call in just one moment, Joe. I would impress that upon him. And I would tell him as an example, I believe I have a reputation in front of the judges of the 19th Judicial Circuit, because I've been in front of them for so long, and they talk. And I believe that when I argue a motion, that if it's a close call, they are going to believe me over whoever's against me, especially if it's somebody, let's say, from Palm Beach that they don't know, or if it's somebody locally that they know will stretch the truth. Unless it's somebody that has equally impeccable character, I am going to get the benefit of the doubt.
Ooh, home field advantage.
Because they know that I will not mislead them, I will not lie to them, that if they bring up a case that hurts my case, I will concede the point and try to argue why it doesn't really apply. I'll do my best. But I will not lie, I will not deceive them. And that's what I tell him. And I tell him, the first time I lie to a judge, and I'm caught, no judge in this entire circuit will ever give me the benefit of the doubt again. It won't take a year or 5 years for me to regain the trust. It will likely be never. That is what character and integrity means. It can be lost in an instant, and it takes a long time to gain. I think I have it here. I don't ever want to lose it. I would rather our kids be taught, have impeccable character, be people of integrity, be honest, especially if you're going into politics, and those be the people that govern our country, then many, many of them that are there now, Republican and Democrat. I don't care. I am looking for somebody who I believe is somebody of integrity, of passion, of honesty, who truly has the people's interest at heart. And that's somebody I'll trust, even if I don't agree with them on a particular policy, because I'd rather have that person in control. Anyway, we are winding down. Let me go to Joe on line 1. Joe, I'm sorry. Let me go to you quickly if you're still there.
That's okay. A quick little comment about the current circus in D.C.
Okay.
In the past election is, there really wasn't much quality integrity to vote for, but, I'm kind of, what really concerns me is the American people and the voters, how much power they're willing to give to an individual with the title of president. They want that person to be sole decision maker over our health care, over every aspect of our life. And, that's every election. I see it more and more towards a dictator. And you're right, our Constitution does prevent
I'm getting
that,
the music, Joe. I'm sorry, I'm getting that music.
So many of them just ignore the Constitution. And, if voting made any difference, I think it would be illegal at this point.
We have a Constitution. If Congress would enforce it, remove those that don't agree, we'd be okay. This is Stuart Address for Ask a Lawyer. I'll be back next week. Thank you for listening.